The cash bail system and pretrial detention, as well as systematic violations of indigent defendants' Sixth Amendment rights, are all massive issues in our country, which have only begun to be effectively addressed in the last few decades. A closer look at these issues and reform of these vital systems in our criminal justice system is urgent to end the era of mass incarceration and systematic racism in America. Adopting the systems of personal recognizance that the District of Columbia has in place is one option that would effectively begin to deal with the issues of unjust bail practices and pretrial detention. The United States criminal justice system has a long history of prejudice and injustice, which favors the privileged and the wealthy over the rest, criminalizing poverty in all but name. Heavy fines, the money bail system, and excessive workloads for public defenders are only parts of a systematic failure on behalf of this country to offer a fair justice system to those of lower incomes. The money bail system in particular ensures that those of lower incomes are incarcerated, even if they are innocent, until their trials, where people who can't afford bail, regardless of innocence, walk free until their trial dates. The vast majority of prison populations in this country is people being held pre-trial because they are denied bail or could not afford it. Despite the lack of significant attention, the problems of criminalized poverty in the United States are very real and far-reaching. Studies have shown that people who cannot afford to pay bail are more likely to plead guilty to crimes they do not commit in plea bargains to attempt to secure lower sentences. Around 97% of federal convictions and 94% of state convictions are a result of plea bargaining. People who cannot pay bail can be held in jail for months until the day of their trials, subjected to violence and terrible conditions, regardless of guilt. This hardship, in turn, subtly pushes people to accept plea bargains in the hopes of getting out faster. The sections of the population most overwhelmingly affected, by virtue of having the lowest incomes prior to arrest, are Black men and women. The criminalization of poverty has manifested in various ways since the founding of the United States. The first wave of bail reform in the United States is considered to be around the 1960s, surging around the same time as the Civil Rights Movement and the War on Poverty. It is no coincidence that these movements all appeared at the same time, considering how interlaced race and poverty are with the problems of the criminal justice system. During this first wave of reforms, the Manhattan Bail Project proved the negative effects pretrial detention had on the recidivism and overall mental health of low-risk defendants, and that low-risk offenders released pre-trial would, for the most part, show up to their court dates. This spurred the passing of the Federal Bail Reform Act of 1966, which had federal defendants released without bail, assigning money bail only if non-financial conditional release would not sufficiently assure the defendant's return to court. This lasted only a handful of years before the Nixon administration, as a second wave of reform came. Alongside the tough-on-crime rhetoric of the 70s and 80s, the Black and the poor, the most overrepresented groups in prisons all over the country, where mass incarceration was growing to unprecedented levels. Today, we are in the midst of the third wave of bail reforms, and we are still currently in the age of mass incarceration. The problems that plague us are multifaceted, and no clear path forward has been found. There are, however, ways to alleviate the problem. First steps on a winding path of recovery that could mean a world of difference for thousands of people every year. The assignment of bail is meant to be based on the amount an individual is capable of paying, as well as the severity of the crime committed. As it stands, people living well below the poverty line are assigned bail amounts they cannot hope to pay, and their options are to stay in jail until whenever the trial may be, or leave a loved one in jail, or to find a way to pay money they don't have. The cash bail system needs to be updated to reflect the reality of the citizens of this country, as well as limit the power that judges have in the assignation of bail. Implicit biases in judges can lead to them giving higher bails for less serious offenses to people of color and other minorities, which also happen to usually be those with the lowest incomes. Another measure that needs to be taken is steps to alleviate the load of public defense attorneys. Every citizen in the United States has the right to an attorney provided by the state if they cannot afford one. But public defense attorneys are overworked. Each defense attorney can have dozens of cases simultaneously that each require hours of attention. This leads to less than adequate counsel, and often public defense attorneys recommend plea bargains simply because they don't have enough time to mount a proper defense. In the following sections, I will discuss the different pre-existing policies that are in place, both those that contribute to and attempt to mitigate the issues in question, such as policies regarding the money bail system and pretrial detention. I will outline some of the research that has been conducted into this topic and conclude with policy recommendations. The United States is one of only 2 countries in the world that have a bail bond commercial industry, which profits directly from people who cannot afford to pay bail by charging them a percentage of the total bail as a non-refundable payment and then covering the rest themselves. In California, one of the biggest states in our country, 60% of the total jail population is defendants awaiting trial, and the average bail is set at $50,000, 5 times what it is in the rest of the country, the yearly salary of many Americans. In one case, a 16-year-old African-American boy was wrongfully charged with robbery and assault and spent 4 years in prison awaiting trial, while a wealthy man accused of murder paid $250,000 in bail and skipped town. Studies have shown that the assignment of bail has increased from 37% to 61% between 1990 and 2009. In California, and supposedly in the whole country according to the U.S. Constitution, current legislation gives judges discretion to set bail so long as it is not excessive. However, in cases like that of Richard, it is easy to see how a system like this could lend itself to abuses. Richard was arrested and his bond set at $360,000, much more than the average American makes in a year. He spent 10 months in a state prison awaiting trial because his wife was unable to pay even the $36,000 required by bail bond companies, where he sustained injuries and abuse, serious enough to require stitches on his head at one point. Whether he was innocent or not did not matter, because the damage to him had been done. While the cash bail system was meant to reduce pretrial crime and flight, the majority of individuals jailed pre-trial are non-violent offenders who pose the least risk. Under California Penal Code Section 1275, judges set the bail by considering prior criminal history, severity of the crime, and threat to the public, as well as flight risk. The current bail system is meant to assess defendants for flight risk and take into account the financial means of each defendant, but it is disproportionately favoring wealthy individuals who are then free to build a solid case from the outside. Not every state in the United States has a bail bond system. In the District of Columbia, the capital of the nation, the money bail system was abolished decades ago, with most cases requiring a simple signature as a promise to appear in court before releasing defendants, which is a working alternative to the cash bail system. In Santa Clara County, California, they adopted a risk assessment system in 2012 and released those who could not afford bail, and of those released, only 5% failed to appear for the court dates. Illinois, Kentucky, Oregon, and Wisconsin all banned commercial bondsmen, putting an end to pretrial profiteering on the backs of the poor. California has begun recognizing this disparity, and in an effort to reform, they have drafted Senate Bill 10, which is meant to go to referendum now in 2020. The bill calls for the creation of a separate pretrial service agency in every county, whose sole task is to provide risk assessment for each defendant, based on the same factors judges already use. However, the judges still retain discretion to set monetary bail, or disregard the risk assessments if they provide the reasoning for doing so. Though this bill is drafted with good intentions and is not the first of its nature to be drafted in California, it provides too much room for people to keep doing the same things they have been. Although it is likely to at least bring the numbers down by a considerable margin, it still leaves the possibility open for injustices against the poor in the system, as these electronic means of monitoring crime and risk assessment tools are all based on prior information collected, which is heavily biased and often colored by racism. Though the criminalization of poverty in the American system is most apparent and talked about in the form of unjust money bail practices, this is by no means its only example. The Sixth Amendment to the Constitution is well known. It grants every criminal defendant the right to effective counsel, regardless of income. The key word in this is effective, because, as people are beginning to realize, the public defender's offices have become extremely ineffective. Each court case, to be properly defended, requires extensive hours of legal research, fact-checking, and investigation, not to mention the funds necessary to hire experts and pay for all that time the public defense office puts into each case. In the years following Gideon versus Wainwright, the historic Supreme Court case which spurred the Sixth Amendment, 3 different public defender systems emerged: contract or flat fee attorneys, assigned counsel programs, and public defender programs. Flat fee attorneys are private attorneys who accept a contract to represent all the indigent defenders in the county for a single fixed price, regardless of workload. The second type, assigned counsel programs, are also private attorneys, but they charge on a case-by-case basis, or an hourly rate, usually if the defendant has some conflict with the local public defender's office. The last one is the one people are most familiar with, which are either state or county-funded public defender's offices. Funding for each of these programs varies state to state, although in most states the majority of the funds come from the state, and in all except Pennsylvania, at minimum, more than half of the funds come from the state. Pennsylvania is the only state in which all forms of public defense are entirely county funded. Pennsylvania's system is unique and also largely ineffective. Because the public defense is paid for entirely by each county, the money comes from things like property taxes, so the system, once again, disproportionately favors those from wealthier counties. Wealthier counties have more money to set aside for public defense than other poorer neighborhoods, making the counties that most need public defense the ones that can least afford it. Underfunded public defense undermines the Sixth Amendment because less funds mean less public attorneys available, leading to increased caseloads and less time and resources spent on each case. In the case of systems like the flat fee attorney systems, attorneys are indirectly encouraged to spend as little time and effort as possible on each case in order to maximize their profits, or if I am being generous, stretch their funds to cope with the unpredictable number and nature of cases which may surge. What this means overall is that the wealthier defendants who are capable of hiring private counsel get a proper defense, while the people with low incomes that depend on public counsel are only one of hundreds of cases that a public defense attorney has to get through. These people are much more likely to have ineffective counsel and end up in prison or taking plea bargains regardless of innocence. One case in Grant County, Washington, perfectly illustrates this issue, as Felipe Vargas was accused of child molestation and was appointed a public defense attorney who, in addition to Mr. Vargas, was trying 500 cases. Studies have shown that a case like Mr. Vargas requires around 63 hours of attention for adequate constitutional counsel. In the case of Mr. Vargas, the alleged victim recanted midway through the case, and his lawyer didn't even know. Mr. Vargas was eventually released when he received a new lawyer who interviewed witnesses and found out that the original victim had recanted. With 500 cases to try at once, it is impossible for any attorney, no matter how good, to provide the amount of attention and research necessary for effective counsel. Cases like Mr. Vargas are not isolated incidents and are more common in poor urban neighborhoods. When combined, the factors of inadequate counsel and unjust bail practices combine to put people with lower incomes at a severe disadvantage when it comes to the dispensation of justice as compared to indigent citizens on the wealthier end of the social spectrum. False confessions are a well-documented phenomenon, but rarely have people associated this phenomenon with guilty pleas, despite the fact that 97% of federal convictions and 94% of state convictions are a result of plea bargaining. Several different studies that conducted throughout the years have found guilty pleas obtained through plea bargaining before defendants have ever been to trial are coercive in nature and should be discounted just as confessions obtained under duress are. One study conducted on a sample of 975 cases in New Jersey examines the causes of guilty pleas and finds that people who are detained pre-trial, that is, those who could not make bail, plead guilty most often. In the study, Sachs and Ackerman defined some of the factors that affect guilty pleas, focusing on the coercive nature of the pleas, with defendants being promised more lenient sentencing if they accept a guilty plea, or being threatened with harsher sentences if the case goes all the way to trial, which is true, as prior research indicates that defendants usually receive a harsher punishment for the same crime if it went to trial than if they pleaded guilty and waived their right to trial. The sample was collected through New Jersey's Criminal Disposition Commission. The study looks at pretrial detention as a factor which incentivizes those who could not afford to post bail to plead guilty simply to get out of jail sooner, especially misdemeanor crimes where time served matches or exceeds what a judge may sentence in the case of a guilty conviction. These individuals are now left with a criminal conviction on their records that in the future may count against them when judges consider the amount of bail to assign. The study found that defendants who are held in jail pre-trial pleaded guilty quicker than those who were released to await trial. Interviews conducted as part of the study with judges, prosecutors, and public defenders reveal that they are all in agreement that those who were held pre-trial plead guilty in an effort to get out of jail faster, regardless of innocence. This study supports the fact that the money bail system, and specifically pre-trial detention as a consequence of it, in fact criminalizes poverty and contributes to the mass incarceration of low-income minorities. The cash bail system has consequences beyond criminalizing poverty, though it is still heavily tied in with the rest of the issues. Defendants who are detained pre-trial are likelier to receive lengthier sentences and accept plea bargains, regardless of innocence, rather than risk going to trial and losing anyways. Beyond the justice system itself, pre-trial detention on innocent individuals can have long-term social consequences, such as mental health issues, like in the case of Khalif Browder, who spent 4 years awaiting trial in a state prison, only to commit suicide once they declared him innocent at 22 years old. Even an imprisonment of a few days can increase the likelihood of a sentence of incarceration and the harshness of that sentence, reduce economic viability, promote future criminal behavior, and worsen the health of those who enter. The disproportionate rate of arrest for minorities, such as Hispanics, the poor, and African Americans, paints a picture of systematic racism in this country. Little wonder that the cash bail system contributes directly to the continuing era of mass incarceration. Mass incarceration is one of the biggest issues in our criminal justice system. It has been an issue since the abolishment of slavery, and since then it has always primarily affected people of color and other racial minorities. We are still in the era of mass incarceration today, despite all the recent attention to the issues. In every single state in the United States, the percentage of people who are incarcerated awaiting trial or unconvicted is over 40% at minimum, with some states breaching 80%. The issues that affect this are vastly complicated, beginning with the broken bail system and not nearly ending at the overwhelmed public defenders and the negative effects of plea bargains. To fix the issues of our criminal justice system, it will take more than one simple fix as a solution, must be carefully thought out and implemented. However, with time and care, even some small changes could begin to change the tide. As the lowest earning demographic pre-arrest, Black people, and particularly women, are the most severely affected when it comes to the criminalization of poverty in the United States, compounded with the disproportionate percentage of Blacks versus whites that are arrested every year. Exorbitant bail amounts and the commercial bail bond industry have made it so that people profit from unequal treatment in the justice system. The issue of bail reform is tangled up in that of pretrial detention. Studies have demonstrated that people held in pretrial detention are more likely to receive harsher sentences and have a higher rate of recidivism in the case of low-risk offenders. In regards to the issues of pretrial detention and money bail, and the way they disproportionately harm the poorest citizens in our country and contribute to mass incarceration and racism in America, there are several reforms being carried out. California's SB 10 is an optimistic, though inadequate attempt at a solution. Critics of the SB 10 and similar risk assessment technologies have stated that they lend themselves to mistakes and are based on past collected information on criminal activity, which is often biased against minorities and the poor. An alternative that has been seen to work is the system adopted by the District of Columbia. There, cash bail was functionally ended with the passing of the Bail Reform Act of 1992, which creates a presumption of unconditional pretrial release. It also says that if for some reason it is necessary to impose restrictions To prevent a flight risk, the measures taken must be the least restrictive possible and cannot be monetary for the sake of public safety. It goes on to specify that if pretrial detention should be necessary, a hearing must be held, and the government carries the burden of proof that it is absolutely necessary. Commercialization of the bail bond system, and therefore the authority of private citizens to arrest other private citizens, must be shut down entirely. And as seen in D.C., with the proper reforms, it will no longer be necessary. The issue of public defense is more difficult to solve, as all of the systems so far implemented have been equally ineffective in varying ways. The flat fee system should be abolished entirely, as it lends itself to greed and corruption, with attorneys worrying about maximizing profits rather than mounting a solid defense. Community-funded public defense is also problematic, as previously discussed, because it lends itself to favoring wealthy sections of the population, while the poor counties which actually need it can ill afford it. The best solution is increased state and possibly federal funding for public defense, with the funds being distributed with priority to counties with higher volumes of cases and lower income rates.